Well, hello there. How is everyone? I hope you are all well. Guess what? We have docs, baby. That's it. We've got docs. We've got like 20 odd docs in the docket for the Idaho 4 case. I wonder what there's going to be. I wonder what they're all going to be like. I've had a brief look over the list. I haven't clicked on any of the documents, so I don't know what they are. But yes, we can go and have a look. We can have a look at them. Have a look at them together. Shall we? Let's start with the first one. I hope you're all well, by the way. I hope that anybody being affected by the Milton is all safe. Obviously, there's a lot of things happening in there. A lot of damage, but damage can sometimes, most of the time, be put right. Loss of life is not reversible. So let's have a look at Doc 1. Hello, Angel. Hello. I need to sort these comment things out. Let's go bring this down here. And then we can do the comments properly as they pop up. Put that there. Hello, Angel. Hello, Wendy. Morning, Austin as well. Morning, Austin. I'm going to go through some of these documents. Hello, Kelly. Would help if I actually put them on the fucking screen, wouldn't it? Would help if I put them on the screen. Does that mean if I click on comments on here? Hello, Beth. Yes. For some reason, they go massive up there. Let's do this. Beth says morning. Morning, Beth. Morning. And Sandy as well. A bad Santa photograph. Yeah, I thought that'd get people's attention. Oh, bad Santa. Bad Santa. Let's have a look. So, number 1. Oh, Penny. Live. It is live. We are alive. So, document number 1 comes now. Brian C. Koberger buying through his attorneys of record pursuant to the Idaho administrative... I'm not going to read them all word for word. Notice of filing documents related to closed hearing on the 10th of the 8th, 2024 under seal. The accompanying document related to the closed hearing being held on the 8th of the 10th under seal to protect the confidentiality of said document. So this is just a under seal document. That's it. Nothing exciting. Hello, everybody coming in. There's a lot, Angel. There's a lot. You too, Kathy. I hope you have a lovely day too. It's not starting well. Freya just messaged me from school saying someone's smashed her fucking glasses. I went, well, you have to tell them who it is because they can then pay for them. She went, I didn't see them. How the fuck did you not see someone throwing something at your face and breaking your glasses? So I'm guessing the doc underneath that will be the motion to file under seal. So that's just in response of that doc. So we don't need to go through that. Something else being filed under seal. So let's just double check this one. I've just been watching Crime Circus. A bit strange, but things just like us about BK in this case. So I've got to go and check out his video. Let me just alter these chat things because they're very hard to read. What the fuck? Fucking disappeared. Bloody disappeared on me. Not very good, is it? I need to see whether that can blend mode normal. Oh, fuck you then. We'll have to struggle with reading the comments on there because it's not staying up long enough for me to change it. The court having before it the motion for permission to file under seal document relating to the closed hearing regarding representation status and good cause appearing, now therefore is hereby ordered that the defendant shall be allowed to file documents under seal relating to the closed hearing. That's when it was. It is further ordered that the documents should be filed under seal because of the confidential nature of information contained within the documents, and that disclosure of documents could impact a fair trial. Like they give a fuck about fair trial. Fucking idiots. Years ago, my oldest daughter put a girl in a wheelchair out of school. The girl is okay. Oh, kids in school. I'd cringe. I get messages. I shit you not. She messaged me every fucking single day. Every day. Right. Request for appointment and transfer of case. Let's have a look at that. This one here. Request for appointment and transfer of case. Prior to the transfer of this criminal case to the court, the Honourable District Judge Monson, 2nd Judicial District, has been appointed to serve as a resource judge. So this here, I did touch on this yesterday. So apparently this is to do with the funding issues, I believe. This is to do with that. That's nothing of any importance, just the funding situation. So let's go to number two. Number two, redacted order governing proceedings and notice of trial setting. Let's have a look. Come on, load. Any vacant. So this is the one that we went through yesterday. So this is just giving us the dates of everything. So we've already gone through this one. We don't need to see this one again. This is just saying the new trial date being the 11th of 5th through to the August the 11th. Sorry, going through to the 7th of November. So we don't need to reread that one. We've done that. Amended notice. What's this one? Amended notice. Scrap that one. Amended notice. Does the defendant have an alibi? Are there interviews? Well, he's just claiming that he was driving around, but they're hoping that the alibi will be proven by further digging into the phone data, I believe. Just get that out of the way. Comes now the state of Idaho by and through the Latah County prosecuting attorney, and hereby gives notice to the court, the defendant and his counsel pursuant to Idaho Code, that at this point in time and based on the information known to the state to date, the following statutory aggravating circumstances pursuant to Idaho Code appear to exist in this case as to the crimes of murder in the first degree, as charged in counts 2, 3, 4, and 5 of the indictment herein. At the time the murder was committed, the defendant also committed another murder. Multiple victims, obviously. The murder was especially heinous, atrocious, cruel, manifesting exceptional depravity, and or by the murder or circumstances around the commission, the defendant exhibited utter disregard for human life, and or the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder which will probably constitute a continuing threat to society. The state gives this notice based on the fact that it has not identified or been provided with any mitigating circumstances sufficient to prohibit the triers of fact from considering all penalties authorized by the Idaho legislature, including the possibility of a capital sentence. Consequently, considering all evidence currently known to the state is compelled to file this notice of intent to seek the death penalty. The state will continue to review additional information as it is received and reserves its statutory right to amend or withdraw this notice. Respectfully submitted, this 9th day of October 2024. So that's that one. amendment notice. So that was that one. So what I need to do is I need to shift that up to the top so we always know where we are, don't we? So the next doc is this. Motion to amend notice pursuant. What's this one then? Oh. Comes now the state of Idaho by through the late account. We can skip that, can't we? Move the court to amend its June 26, 23 notice pursuant to Idaho Code by withdrawing the Idaho Code 192515 aggravating factor. The proposed amendment notice pursuant to code is attached hereto. In support of this motion, the state has continued to review this case and prepare for upcoming pre-trial motions, practice, and trial. And the state has determined that the remaining 4 aggravating factors contained in the state's notice pursuant to Idaho Code adequately reflect the state's interest and position on penalty. Wherefore, the state respectfully prays that the court grant leave for the state to file the attached amendment notice pursuant to Code 4004A. Objection to defendant's motion regarding non-statutory aggravating evidence. A lot of objections. I object. Sounds like fucking Johnny Depp trial. State's objection to the defendant's motion regarding non-statutory aggravating evidence. Comes now the state. We know who they are. Provide notice of every alleged non-statutory aggravating fact circumstance it may rely on at any sentencing trial to prove beyond a reasonable doubt every alleged non-statutory aggravating fact circumstance motion defendant's requested notice is already governed by and defendant's argument that the state must prove non-statutory aggravating evidence beyond a reasonable doubt conflicts with Idaho Supreme Court precedent. This looks like this is going to be a long doc. Idaho's capital sentencing scheme dictates the appropriate notice that each side must give for all evidence it intends to introduce at the sentencing phase in a capital case. The statute governing the special sentencing proceeding states that the state and the defendant shall be entitled to present all relevant evidence in aggravation and mitigation. The phrase all relevant evidence in the statute includes non-statutory aggravating evidence. See State versus Hall. Thank you very much, Mr. Gunner. Slapping in there with the super chat. He's now going to bed. Long night, brother. Long night. Where are we? The statute requires the disclosure of all evidence either side intends to rely on at the special sentencing proceeding in accordance with Idaho Criminal Rule 16 IC blah blah blah. Defendant cites his statute improvingly, and it is unclear to the state what more defendant seeks. To the extent defendant is requesting more notice than the notice required by the statute, the court should reject defendant's request. Oh, so if we want more time, we get it. If he wants more time, fuck him off, because he ain't getting it. That's what it seems like. State does not have to prove non-statutory aggravating evidence beyond a reasonable doubt. Of course you don't. Of course you don't. Idaho's capital sentencing scheme requires the state to prove at least one statutory aggravating circumstance beyond a reasonable doubt, but it does not require the state to prove non-statutory aggravating evidence beyond a reasonable doubt. See Hall 163, blah, blah, blah. In Hall, the court reaffirmed that the fact finder in a special sentencing proceeding can consider circumstances not statutorily listed and not expressly found beyond a reasonable doubt. Moreover, the statute governing the special sentencing proceeding lays out in detail what the jury must find for a sentence of death, including that it must find the state proved the existence of at least one statutory aggravating factor beyond a reasonable doubt. Entirely absent from the statute is any mention of proving non-statutory aggravating evidence, much less proving it beyond a reasonable doubt. Defendant supports his argument by citing a case that provides no support at all. That was a good one then. That was a fucking good one then, wasn't it? Tennyson did not address non-statutory aggravating evidence. It held only that the jury must be convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors before a sentence of death can be imposed. Thus, this court should deny defendant's request for an order that the state must prove non-statutory aggravating evidence beyond a reasonable doubt. Difficult one. I think when you got to the point where you're going to execute someone, though, I think everything should be beyond a reasonable doubt, don't you? Absolutely everything. Objection to defendant's motion to strike the future dangerous aggravator. I think this would be fucking hard. Comes now, state of Idaho, leave that. To defendant's credit, he acknowledges from the outset that his motion to strike the future dangerous aggravator, often referred to as the propensity aggravator, flies in the face of well-established precedent. Defendant's motion to strike future dangerous aggravator, specifically, defendant acknowledges that the Idaho Supreme Court and the United States Supreme Court have upheld the constitutionality of considering propensity as an aggravator in a capital case. However, defendant dismisses with a figurative hand wave the Idaho Supreme Court's decision in Creech and the United States Supreme Court's holding in Jurek versus Texas, both of which are binding on this court as problematic, and plows ahead with three arguments in support of his motion. First, he asserts that the propensity aggravator fails to narrow the class of death-eligible defendants. Secondly, he contends that the propensity aggravator is impermissibly vague. Finally, he claims that the propensity aggravator is irrelevant to culpability, and therefore cannot be an aggravator. This court cannot overrule the Idaho Supreme Court. Hello, people coming in. Welcome. We're going through these docs with a fine-tooth comb. There's a lot of objection, Your Honours. Objection. Overruled. Sustained. As elsewhere in his briefing on the death penalty, defendant asked this court to enter a ruling contrary to a specific holding of the Idaho Supreme Court. This, of course, the court cannot do. The Idaho Supreme Court unambiguously set forth its authority in State versus Guzman. To this court falls the obligation to be and remain the ultimate authority in fashioning, declaring, amending, and discarding rules, principles, and doctrines of precedential law by application of which the lower courts will fashion their decisions. In other words, we are the boss. You shall follow. We say you do. We say you do. This court has been and remains the full arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. So in other words, we have always followed them. They have been the boss, and we just do as we're told. And if things change over time, we change with them. There we go. I blame Harsh for my bubble butt. I love my meat and potatoes. I like it. I like it. Let me see if I can make it bigger. It's going to be hard to read that chat thing, but I don't know how I can change it. I think I can do that, actually. Look, edit text. Can we do, like, black text or something? Where the fuck's that gone? Oh, it disappeared again. That's not helpful. Anyway, let's carry on. As we were, having admitted that binding appellate case law forecloses his argument, defendant's motion should be denied on this basis alone. And the propensity aggravator appropriately narrows the class of death-eligible defendants. I do agree with this. Obviously, if someone's got a propensity to go out and kill again, but again, I feel that this is slightly just lip service at this point, because if someone's, if they're found guilty of this crime, then does it actually fucking matter? They're going to get, well, especially in Idaho, they're going to go, aren't they? As noted above, defendant acknowledges that the constitutionality of the propensity aggravator was upheld by the Idaho Supreme Court in State versus Creek. There, the court held that the propensity aggravator narrows the class of death-eligible defendants and even provided an example of the type of murder that would not fall within the scope of the propensity aggravator. Here, it cannot be asserted that propensity circumstance could be conceivably be applied to every murderer coming before a court of this state. We would construe propensity to exclude, for example, a person who has no inclination to kill, but in an episode of rage, such as during an emotional family or lover's quarrel, commits the offence of murder. We would doubt that most of those convicted of murder would again commit murder, unless they got into another relationship and got pissed off with that partner. I think that that's arguable again, isn't it? Propensity language to specify the person who is a willing, predisposed killer, a killer who tends toward destroying the life of another. And again, I feel that this is arguable because you don't know if you're a predisposed killer until you're put into that situation. And if you've got into... How many of us have been in a quarrel with our partner and it hasn't resolved in murder? And I think that's an argument for another day. We would hold that propensity assumes a proclivity and susceptibility and even an affinity towards committing the act of murder. Ignoring the specific example provided by the Creech court, defendant complains that the Idaho Supreme Court gloss is a list of synonyms that define anyone who would commit murder as already defined by the legislature and does not accomplish the genuine narrowing required by the Eighth Amendment. Unfortunately for the defendant, one's personal interpretation or belief of the Idaho Supreme Court's holding in Creech is irrelevant to this court's determination. In other words, fuck your feelings. Don't care how you feel about something. Fact isn't feelings. Hello, phonetics. Hello, people, as you're coming in. I hope you're all well on this beautiful, beautiful Friday morning. Here again, defendant acknowledges that the law is not on his side. No shit. Under his heading is permissibly vague. The defendant next writes that the United States Supreme Court held that future dangerousness was not vague and it was something judges had to do all the time. Jurek versus Texas defends motion to strike future dangerousness aggravator. Defendant is correct. The United States Supreme Court upheld the constitutionality of a future dangerousness or propensity aggravator in Jurek versus Texas. In Jurek, the court addressed an argument similar to the one that defendant poses to this court. In the Texas statutory scheme at issue in Jurek, jurors in the capital sentencing proceeding had to answer 3 questions related to aggravation in the affirmative. One of those questions was whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. ID at 269, on appeal, direct defendant argued that it is impossible to predict future behavior and that the question is so vague as to be meaningless. ID at 274, rejecting that contention, the Jurek court held that prediction of future criminal conduct is an essential element in many of the decisions rendered throughout the criminal justice system, and that what is essential is that the jury have before it all possible relevant information about the individual defendant whose fate it must determine. Good morning, Chris. Good morning, good morning, good morning. Good morning, anyone else coming in as well? Yes, so accordingly, the court concluded the Texas statutory scheme did not violate the Constitution. Idea 276, the court also explained that by authorizing the defense to bring before the jury at the separate sentencing hearing whatever mitigating circumstances relating to the individual defendant can be adduced, Texas has ensured that the sentencing jury will have adequate guidance to enable it to perform its sentencing function. Defendant then argues that the propensity aggravator should be struck for the sake of clarity to the jury, arguing that there is potential for confusion where certain types of mental disorders could be taken as both aggravation and mitigation, arguing that, practically speaking, every case where a jury is asked to find a person is likely to pose a threat of future dangerousness will involve underlying significant disturbances in that person's mental functioning. See, this concerns me, this here, because I've always wondered whether there is going to be something brought up about Brian Kohberger's mental acuity, whether there is something in the background that is going to be utilized in some way, shape, or mean here. We've all sort of thought it, haven't we? We've all looked at Brian Kohberger and wonder whether he is got some for he's on the spectrum of any description, something like that. It's I don't know. It's this here to want to strike that, but they're trying to strike everything. So maybe I'm reading into that too much, but I see the point there. What they're basically saying is you couldn't say if someone was autistic, for instance, that could be both an aggravator and a mitigator. But there we go. Redacted new video, pretty mind-blowing. I haven't. I need to watch it. A few people have spoken about redacted channels videos. I'll go and check it out. I'll have a look. Practically speaking, every case where a jury is asked to pose for mental functioning. Future dangerousness aggravator page 7. Defendant asserts that from the Supreme Court's view, a mental illness of a type that renders a person unable to understand the meaning of or reason for it bars the application of the death penalty. In support of this argument, defendant cites Ford versus Wainwright, but that case is wholly irrelevant to the defendant's argument. Ford versus Wainwright dealt with a defendant who had appeared to be intellectually normal at the time of his conviction and sentencing to death. Ford developed a severe mental illness in the years that followed, displaying symptoms of schizophrenia that included referring to himself as Pope John III and claiming to have appointed 9 new justices to the Florida Supreme Court. The court ultimately remanded the case for the determination of the defendant's sanity, explaining that it is no less abhorrent today than it has been for centuries to exact in penance the life of one whose mental illness prevents him from comprehending the reasons for the penalty or its implications. In any event, there is nothing in the record that suggests that the defendant in this case has a mental illness of a type that renders him unable to understand the meaning of or reason of the application of the death penalty, nor is there any indication as of this time that evidence of mental illness would be presented at sentencing by either prosecution or the defense. So that now answers the question that we literally just had. So currently, there is no indication at this time that evidence of mental illness would be presented at sentencing. So that's a good little nugget there. That's a good bit of nugget. I did see Dope, you had commented something there. But that's the mitigating factors that will try to be used to get death penalty removed from sentencing if he is found guilty. Yeah, I get that. I get that. But that is interesting, because I did wonder whether they were going to try and say that he was a mental case or something. Accordingly, this argument is wholly irrelevant or simply not ripe. So, yeah, so something could come up in the future. By stating that not ripe means at the moment. So things could change later, but currently we do not have anything. Future dangerousness is a relevant sentencing consideration. I don't think we need to read through all that. We know where they go on with that. HAC aggravator. Just click on this. What's this one? Comes down, blah, blah, blah. Heinous, atrocious, and cruel aggravator. It is well established that a capital sentence scheme must generally narrow the class of persons eligible death for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. In a companion notion filed contemporaneously with this one, defendant correctly acknowledges that the Idaho Supreme Court held that Idaho's capital sentencing scheme meets the standard. See defendant's motion to strike under utter disregard. As the Supreme Court explained in Wood, this court has upheld the constitutionality of its death penalty statutes on numerous occasions. Nevertheless, the defendant advances two arguments. First, he argues that the court should find that the gloss placed on the HAC aggravator by the Idaho Supreme Court was in violation of the Idaho Constitution. Defendant's motion to strike utter disregard aggravator. Second, he asserts the Idaho criminal instruction for the HAC aggravator does not contain the necessary limiting construction set forth by the Idaho Supreme Court in State versus Osborne. For the reasons set forth below, both of defendants' arguments fail. So the same thing again, the court cannot overrule the Idaho Supreme Court. So we don't need to read through that. It's just going to be a repeat of what it was before. It's going to give you an example of how the Supreme Court has handled it, what the outcome was, and they're basically saying, look, they rule us, and we can't do something different to the Supreme Court. Yeah, so they're literally just giving you examples. Defendant's argument that the Idaho Supreme Court's decision in Verxa versus Alphonsus Regional Medical Center reserved its ability to provide judicial interpretation to statutes itself evidently wrong. In Verxa, and in a passage quoted by the defendant himself in Idaho Supreme Court, merely explained that we have never revised or voided an unambiguous statute on the ground that it was patently absurd or would produce absurd results when construed as written, and we do not have the authority to do so. So, what's this then? The term heinous, atrocious, and cruel are intended to refer to those first-degree murders where the actual commission of the first-degree murder was accompanied by such additional acts as to set the crime apart from the norm of first-degree murders, which, again, this little snippet here is telling, isn't it? It is basically some of the things we've heard about the crime scene, about it being horrendous, and some of the details that we've kind of been given, but we're unsure about the accuracy of them. Yes. The terms heinous, atrocious, or cruel are intended to refer to those first-degree murders where the actual commission of the first-degree murder was accompanied by such additional acts as to set the crime apart from the norm of first-degree murders. But again, this brings into question here of the time frame of the murder itself. We're led to believe at this stage that all of this thing that happened occurred in a period of approximately 8 minutes, when you factor in when Brian was driving, apparently, when his car was seen and when it was driving around. We have an 8 to 12 minute time frame. And this isn't now just about getting in and getting out. This is about getting in and causing utter carnage. A murder is heinous if it is extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. It might be thought that every murder involves depravity. However, exceptional depravity exists only where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. And I know that there's been some things that were said about injuries potentially sustained to individuals, the removal of certain body parts. Again, we don't know that. It's all, yeah. I think that, hello, law officers of Andrew D. Myers. Mr. D. Myers is in the house. Hello, my friend. I hope you are well. Been a while since we crossed paths. Conclusion. Defendant's constitutional claims are foreclosed by well-established case law, and this motion is legally meritless. It should be denied. Denied. This will be interesting. Multiple victims aggravator. How the fuck can they get around that? Comes now state of Idaho argument. Defendant does not make a legal argument in his motion to strike the multiple murders aggravator. Instead, he attempts to craft a public policy argument. Unfortunately for the defendant is referring to Idaho Code section 192515, which applies when, at the time of the murder was committed, the defendant also committed another murder, which is pretty straightforward, isn't it? Again, let's read this because this is going to be quite interesting how they do try and get through this. And look, I'm all for fairness. You know, I don't believe that they have proven or been able to show, especially publicly, that Brian Kohberger is guilty of the crime. And I appreciate that there is a legal route to take as well. So they will, the defense will try and chip away at every single thing they can. But I do like to see how you, especially when the crime itself is a mass murder, how you try and remove a multiple victims aggravator. Why did Chapman say 2 o'clock is the worst hour? Good question, Andrew Wright, and one that we have had for a while. Right, so defendant is referring to blah, blah, blah. Going forward, the state will refer to this aggravator as the multiple murders aggravator as it more closely reflects statutory language. But Jay, yeah, this will be a Jay Logston. This will be a Logston deal. There is no legal authority that supports his motion. Defendant claims murders cannot be aggregated in a manner that makes the act of malice a forethought murder aggravated. Defense motion to strike multiple victims aggravated. He boldly asserts there is no way that in which two murders can be aggregated in a way that makes the act of murder aggravated, except to resort to one of the other aggravators. In support of this contention, he does not cite a single statute or appellate case, but rather an article from New York University Review of Law and Social Change. This article does not even stand for the proposition that defendant claims it does. The article does not argue that multiple murders is not an appropriate aggravator in a capital case. Rather, the article analyzes a study on capital cases in Texas and the extent to which non-legal considerations play a role in prosecutor and jury decision-making. I know the article is summarized as follows. The present study seeks to determine the effects of several legal and extra-legal factors on prosecutors' decisions to seek death sentences and juries' decision to impose death or life sentences in Texas. Many legally relevant factors, such as the defendant's prior record and the killing of multiple victims, which could be expected to influence the punishment decision, are considered. Factors not legally relevant to the case include individual characteristics such as race or gender of the offender and victim. If prosecutors and juries' decisions were not made on the basis of legally relevant factors, it may be concluded that the death penalty was imposed arbitrarily. If decisions were based on legal factors, it may be concluded that the punishment was imposed discriminatorily. Finally, if the decisions were consistently based on identifiable legal factors, the conclusion may be drawn that death sentences were fairly and equitably imposed. Put another way, the article specifically refers to multiple victims as one of the legally relevant factors to consider in capital cases, and further states that death penalty sentences are fairly and equitably imposed when factors consistently form the basis of decisions to impose the death penalty. If the article can be read to present any opinion at all on the multiple murders aggravator, it is that it is fair, legitimate, and appropriate consideration in a capital case. Citing blah, blah, blah. We don't need to read that bit. I don't think. Double weighting aggravator is impermissible. The state has alleged more than one statutory aggravating circumstance in this case. You must consider whether the state has proven the existence of one or more of the statutory aggravating circumstances beyond a reasonable doubt by relying on the same facts or independent facts. So this is kind of an easy win for the prosecution, isn't it? That's why they're trying to get it, why the defense is trying to get it struck, because it is quite an easy win. At the end of the day, there's multiple victims, and that is one of the aggravating factors towards choosing the death penalty should it go to that, should we go down that route. And yeah, this is an easy win. An easy win. The same facts without more cannot be relied on to find more than one statutory aggravating circumstance beyond a reasonable doubt. Independent facts must exist for each statutory aggravating circumstance in order for you to find that the state has proven multiple statutory aggravating circumstances beyond a reasonable doubt. Conclusion: defendant has failed to provide any binding legal authority for this court to strike the multiple murders aggravator. Instead, he provided the court with a law review article that favourably describes it as a legally relevant consideration, and an Idaho case that did not even address the multiple murders aggravator at all. His motion is legally meritless and should be denied. And again, like Dream Suburb, they've got zero proof against him. They're going to have evidence against him. It's unfair, and it would be wrong of us to say they've got no evidence against him. I don't think there's enough to say that he did the crime beyond a reasonable doubt. Obviously, there are things around the case that don't look right, and there's massive gape and holes around the case, but hopefully the trial will fill in these holes, or will fall apart. It will either fall together in the trial or it will fall apart. When we actually get to the trial, it will be, and this is why I want to get to this trial. And some of you have been incredibly kind in assisting me on that journey to get there. But that's what we want to see. I want to see this trial. First, I want to physically be there when it falls the fuck apart or it falls together, because it can't stay as it is, because it's so up in the air. It is so up in the air. What do we got here? State's objection to defendant's motion to strike a disregard aggravator. Argument. In this case, the state is pursuing the utter disregard aggravator. The aggravator applies when the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Again, this is just an easy win, isn't it? You're not considering human life if you're extinguishing human life. It's that simple. It's well established that a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty, and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. So again, this is just, we don't need to read all this. This is going to be very similar to the first one, which is basically talking about this wasn't a flash in the pan murder. This is someone who made a conscious decision to extinguish life. He had no regard for human life whatsoever. It's just talking about the future danger, the future dangers. Future dangers. Let's have a look. This one. State's objection to expert testimony from Eliza P. Cover. Comes down the state of Idaho by and through. Professor Cover's testimony would not be helpful to this court. It is now well established in Idaho that testimony containing conclusions of law by an expert witness is generally inadmissible. When an expert witness offers a legal conclusion, it evades the province of the court to determine the applicable law. Defendant submitted as Professor Cover's expert report on law review article titled Narrowing Death Eligibility in Idaho, an empirical and constitutional analysis. As the title suggests, Professor Cover's article is a legal analysis of Idaho's capital sentencing scheme. The article sets out her view of Supreme Court precedent on capital punishment and ultimately concludes that Idaho's high rate of death eligibility shows that the capital scheme is failing to genuinely narrow the class of persons eligibility for the death penalty, and therefore violates the Eighth Amendment. Such legal analysis and argument is adequately performed by the defendant's counsel, and admitting it through Professor Cover's testimony would invade the province of the court to determine the applicable law. So what they're basically saying here is this is someone's opinion about the law, and people's opinion shouldn't be taken into consideration. The same as, I suppose, the argument would be, it could be determined that Steve Gonsalva's opinion is Brian Kohberger is guilty and he should be executed, but that shouldn't be considered because that's someone's opinion. We need to go by the law, we need to go by the facts. It's as simple as that. So again, I don't think we need to read any further. They're just trying to strike her from it. Barbara C. Wolf. I think this was the same sort of thing. Again, more opinional. Objecting proposed testimony by Dr. Barbara C. Wolf in support of defendant's method of execution claim. As the state explained in its response, defendant's method of execution claim is not ripe for the judicial determination. Objection. The defendant's motion to strike takes notice of intent to seek death penalty on the grounds of vagueness in balancing aggravators and mitigators, which means Dr. Wolf's testimony does not satisfy Rule 702 of the Idaho Rules of Evidence because it will not help the trier of fact to understand the evidence to determine the fact. And they're basically saying you can't complain about the methodology of execution when you don't even know what the methodology is going to be, or it's not ripe. We're not there yet. Intent to seek the death penalty. Let's have a look. How is everyone anyway? Got some more people coming in to read these docs of us. State's objection to defendant's motion to strike notice of intent to seek death penalty on grounds of failure to present aggravators to a neutral fact finder. Blah 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 blah. Just scanning through. What do we got? Wolf was on the OJ case. Probably saying the same thing. Comes now the state of Idaho by and through the Latah County prosecuting attorney and hereby objects the defendant's motion to strike notice of intent to seek the death penalty on grounds of failure to present aggravators to a neutral fact finder. The thrust of defendant's argument is that the applicable aggravating factors in the capital case must be presented to a grand jury. His argument is squarely foreclosed by binding Idaho Supreme Court precedent. Same old. Both Article 1, Section 8 of the Idaho Constitution, the Sixth Amendment of the United States Constitution, require the state to provide notice to the accused of the crime charged by the indictment or information pursuant to Idaho law. The state must include in the information or indictment a plain, concise, and definitive written statement of the essential facts constituting the offence charged. In a capital case, the state must also provide notice to the accused of the intent to seek the death penalty within 60 days of the entry of a plea. The notice must include a listing of the statutory aggravating circumstances by the state will rely on in seeking the death penalty. The statutory aggravating circumstances are not elements of a crime, which means there is no constitutional requirement that the state present evidence demonstrating probable cause for each aggravating circumstance. Defendant concedes that Abdullah is fatal to his argument because the Idaho Supreme Court held that aggravators do not have to be presented to the grand jury. He insists, however, that the decision in Abdullah is wrong and should be overruled. The length of the defendant brief suggests that he believes this court has the power. He is, of course, wrong. Again, this is basically, we follow the US Supreme Court. It is what it is. We can't change anything. Like it or fucking lump it. Like it or fucking lump it. Grounds of international law vague. Don't think there's any point in reading what the objections to them are. No, I don't think there's any need to read through them. This one, however, a little bit different. In the District Court of the 4th Judicial District of the State of Idaho, blah, blah, blah. State's objection to defendant's motion to strike state's notice of intent to seek death penalty on grounds of contemporary standards of decency. Comes now analysis. The crux of the defendant's argument is that there has been a major shift in public opinion. This is what we need. Major shift in public opinion regarding the morality, decency, and humanity of the death penalty. Defendant suggests this shift has taken place among the states, internationally, and among religious and professional organizations. Because of this shift in public opinion and the alleged downward trend of the application of the death penalty, defendant argues that the punishment now violates modern standards of decency, ultimately deeming the death penalty cruel and unusual punishment in violation of the 8th and 14th Amendments to the United States Constitution and Article 1, Section 6 and 13 of the Idaho Constitution. Hello, Sloan. Hello. The 8th Amendment states excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. U.S. Constitutional Amendment 8, the 8th Amendment, is applicable to the states through the 4th Amendment's Due Process Clause, Robinson versus California. Article 1, Section 6 of the Idaho Constitution also prohibits the imposition of cruel and unusual punishments. Capital punishment is not prohibited under the United States Constitution, and the states may enact laws specifying that sanction, Bays versus Reese. When considering whether a punishment violates the 8th Amendment, the court first considers objective indicia of society standards as expressed in legislative enactments and state practice to determine whether there is a national consensus against the sentencing practice at issue. State versus Abdullah. Next, guided by the standards elaborated by controlling precedents and by the court's own understanding and interpretation of the 8th Amendment's test, history, meaning, and purpose. The court must determine, in the exercise of its own independent judgment, whether the punishment in question violates the Constitution. In State versus Abdullah, the Idaho Supreme Court held that Idaho's death penalty scheme does not violate the 8th... Are we bad? No, we're not. Okay, carry on. To the United States Constitution, 158, blah, blah, blah. The defendant argued that our evolving standards of decency, which mark our progress as a maturing society, no longer support the death penalty as an acceptable sentencing option, which is a good it is an argument, and a lot of people are going to agree with this. You know, we don't have the death penalty in the UK, and there are many states across the United States that don't have the death penalty. In fact, this case here, if you look at where Brian Kohberger was residing in Washington, to what is it, 9-10 miles down the road in Moscow, you have the death penalty. So literally a short drive from point A to point B is the difference between life imprisonment versus execution. And I feel that and this is just my personal opinion, and I do feel that there is certain situations where the death of somebody is absolutely warranted, I suppose, if they absolutely pose a risk to society. But I think if you're going down that route of having a death penalty, then it has to be the same across the board. I don't think that you can literally have a 9 miles drive that is the differentiating factor between life and death. I can't get my head around. And I've always been interested in the death penalty. I did about the death penalty as part of my, I suppose, the UK equivalent to a dissertation when I was 16 years old for my GCSEs. So I was covering death penalty in the United States as a kid myself. He cited the increasing numbers of states that have abolished the death penalty or issued moratoriums on scheduled executions, as well as public opinion polls that tend to denounce the death penalty as a sentencing option. The court rejected his claim. While the defendant may have identified a shift in support for a position of the death penalty, the shift does not provide objective indicia of society's standards, such as legislative enactments or execution action, to allow this court to determine that there is a national consensus against the death penalty as a sentence for first-degree murder. Defendant's argument here is no different than the argument the court rejected in Abdullah. The majority of the states, the military, and the federal government continue to allow the death penalty as a sentencing option. The Death Penalty Information Center, as the court noted in Abdullah, it's difficult to regard a practice as objectively intolerable when it is in fact widely tolerated. Yeah. So there you go. It's basically saying just because these don't like it, the fact that these do like it, we're carrying on. We'll be carrying on. Hello, truth and transparency. Have a great Friday. Have a great weekend. Good to see you. So yeah, that was a conclusion there. Dave might not like the death penalty, but Jeff, he fucking love it. So we're cracking on. Grounds of speedy trial, prevent an effective... let's see if I attack this fucker. States object speedy trial. On grounds of speedy trial, preventing effective assistance of counsel. This should be interesting. Let's see where they route this. Comes now, the state of Idaho, by and through the Latah County prosecuting attorney, and hereby objects to defendant's motion to strike the death penalty on grounds of state speedy trial preventing effective assistance of counsel. Defendant claims that this court must strike the death penalty because he cannot be forced to choose between his right to a speedy trial under the Idaho Constitution and his constitutional right to effective assistance of counsel. His argument rests entirely on the inaccurate premise that the Idaho Constitution sets a hard and fast 6-month deadline for his trial, because the Idaho Supreme Court has held otherwise. This court should deny defendant's motion. See, I fucking agree with it. I actually agree with that. You are... Like, a lot of people go on about the speedy trial, don't they? Like, why did he wait for a speedy trial? And I always thought, well, because he got fucking funneled into a corner, he had no choice. He had no fucking choice. Because the Idaho Supreme Court was held otherwise, the court should deny the defendant's motion. All criminal defendants in Idaho have a constitutional right to a speedy trial. In other words, you can take the risk or not, son. Take a fucking punt. Go on, see how you get on with it. Or you can waive your right. The right to a speedy trial under the US Constitution is assessed by the balancing of 4 factors: length of the delay, the reason for the delay, whether the defendant asserted the right to a speedy trial, and the prejudice to the defendant. See Barker versus Wingo. This approach has been adopted in Idaho for determining whether a speedy trial violation has occurred under the Idaho Constitution. In fact, the only difference between the federal and state constitutional rights to a speedy trial identified by the Supreme Court is when the speedy trial clock begins. The clock begins for the federal right at the time of arrest, and for the state right at the time of arrest or the time charges are filed, whichever occurs first. From there, both state and federal constitutional claims turn to the balancing test under Barker. Predictably, the case-specific balancing test adopted by the Idaho Supreme Court has resulted in a wide variety of permissible lengths of delay before trial. Delay from 15 months to 17 months have all been found permissible under the Idaho Constitution. So they're now basically saying, if you wanted a fucking delay, you should have asked for one. You'd have got given it. Other people have been given it. It's your own fucking fault. Defendant attempts to free himself from his well-settled case law simply by opining that the Idaho Supreme Court has wrongfully deviated from the right to a speedy trial, as it was defined by the framers. He pleads with this court to hold the decisions of the Idaho Supreme Court were wrongfully decided. He asked this court to instead side with the legislators of other states and draw a firm line at 6 months in the Idaho Constitution. Unfortunately for the defendant, this is not how constitutional interpretation or the law generally operates. See State versus Guzman again. The Idaho Supreme Court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. We've seen this again. Once defendant's fatally flawed premise is corrected, he's alleged Hobson's choice between the right to a speedy trial and the right to effective assistance of counsel is not a choice a defendant has to make at all. In fact, the Idaho Supreme Court has expressly held that a constitutionally permissible reason to delay trial is so that defense counsel has adequate time to prepare. See, I don't think that fucking exists to it. Don't think that exists. That's like saying it's just like saying you should have just asked. If you could prove that you needed more time, then you'd have been given more time. The problem is it's whether they accept your reason to ask them for more time, which I think we've seen consistently throughout this situation, that the prosecution have not wanted to give anything. You know, even when Edelman was doing his surveys out, they shut that shit down immediately, when in reality they had done worse things that they were accusing Edelman of, and their gag order imposition had actually further fueled the shit that was out in the public. There we go. While it is true that a defendant misses out on a statutory benefit of a 6-month deadline for trial when he takes an action that results in the delay of his trial, defendant has not asserted the loss of a statutory benefit as part of his argument. Even if he had, there is nothing impermissible about forcing a defendant to choose between a statutory benefit and a constitutional right. Where the compulsion does not force the defendant to forfeit any constitutional entitlements is not contrary to or an unreasonable application of U.S. Supreme Court precedent. A defendant is made to choose between a constitutional benefit and a statutory benefit. Here, the defendant chose to waive all his speedy trial rights. See waiver of speedy trial, felony filed. He did so in writing and after consultation with his attorney and Taylor. See, there was nothing impermissible, much less unconstitutional about this waiver, and his court should deny this motion, which this was probably fucking Anne's doing, this was. This was fucking Anne's doing. Back in the earlier days. Back in her earlier days. Response to defendant's motion to strike felony murder aggravator. This is a fucking interesting one. Lots of people coming in. Hello, people. Hello, people. We're getting there. There's not many left. Not many left. Smash the like button, by the way. 407 people in, and we got 190 likes. Hit the like button if you think Brian Kohberger. Hit the like button if you feel that they have currently failed to show that Brian Kohberger is guilty beyond a reasonable doubt. Come on, that should get the likes up. And if you think otherwise, hit the like button 3 times. On September 5th, 2024, defendant filed his motion to strike felony murder aggravator. Contemporaneous with his objection, the state has filed a motion for leave to amend notice, pursuant to Idaho Code, yada, yada, yada. Along with an amended notice under Idaho Code, under the amended notice, the state will no longer be pursuing the felony murder aggravator. Accordingly, the defendant's motion to strike felony murder aggravator will be rendered moot and should be denied. So, they are no longer pursuing the felony murder aggravator. Probably because they've got all the other fucking stuff. Got more stuff on the board. They don't need to do that. Amended certificate of delivery. What's been delivered? What's been delivered? Amended. Hit that like button if listening to Harsha's voice makes your morning smoother. Smooth FM. Court Talks. I hereby certify that true and correct copies of the following documents were served on October 9th, 2024 via I-Courts to Ann Taylor. I further certify that on the 10th day of October 2024, the same documents were served on J. Logston and Eliza G. Masseth via email. Amended notice. Motion to leave to amend notice pursuant. Order to leave. State's objection. All of these. Speedy trial. There we go. That's just docs. A load of docs there. If you want to pause it, you can pause it. I'm not going to fucking read that list. Amended objection to expert's testimony from Eliza Cuther. We've already seen some of that. I don't need to see that one. Notice of no objection to motion to leave to attended notice. And the order to leave to amend notice pursuant. See what this last one is. No, that's not. That's it. That is all. 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 Hooray! Fucking right. So that is a load of your docs, mate. That's a load of your docs there. That was a lot of docs, wasn't it? That was a lot of docs. But we have a trial date. The trial is now the 11th of November 2025. And it's going to run until the 7th of November. And yes, I do want to attend. Like I say, I want to attend because I want to see this either fall together or I want to see it fall apart. That's as simple as that. I have not seen enough, personally, to believe that Brian Kohberger did the crime. I'm not naive. I've said this consistently. I'm not naive to believe that he couldn't have done it. You know, anybody I feel is capable. I just feel that the vast majority of the stuff that's out in the public domain and being used as a clutch for people who want to say that he's guilty, they've come from untruths or bending on facts. And yes, the defense do have some things that do ultimately point to guilt if there is not, how can I say, Andrew D. Myers says the defence can file reply briefs up until October 24th. Yeah, and it's... Like I say, I speak to so many people. You know what it's like. You do videos on Brian Koberger, you talk about certain things, and you get people who jump on you in comments, or they'll email you. And I've got an email for you later, I'll tell you. I have to put up with this shit. You're going to start putting up with it. I'm going to do fucking fucked up email Fridays from now on. But... You know, and they'll say, well, they'll turn around and say, yeah, but he was wearing gloves and he was taking stuff out of his rubbish and stuff like that. Or they'll say, but his car, he was definitely driving his car. How can it be that the murderer was driving a white Hyundai Elantra and Brian just happens to have a white Hyundai Elantra? And these things, they're indicative of the possibility, but they're not solid evidence that can be at this time shown as fact to support that he 100% did the crime. There's a long way to go. Some people don't take a lot of convincing, and that's where people end up getting wrongfully convicted, and people get wrongfully convicted. People are wrongfully convicted all the time, and I fear that it is because of this mentality that people see something and they automatically jump on it. They automatically jump and attack. It's attack mode. And when you've got the likes of Steve Gonsalves, bless him, doing what he's doing, and you've got such a support network for the family, it's like so many things that he has said, like even this last conversation with Nancy Grace, I fucking don't get it. I genuinely don't understand how they can get away with it. I don't understand it. And yeah, I know there was some stupid elements, like he turned around and said that he'd been studying for a century or whatever it was. You know, that's a verbal typo, as I call them, verbal typo. But realistically, there is things that is being allowed to be said by people who are pertinent to the case and how people feel about it, being allowed to say things that shouldn't be being said. And I just fear that this could, in the future, lead to a collapse of this case. And that is getting to the point where it's a real concern. Angel, they put too much believing law enforcement because we all want to, but they are human and also make mistakes. They do make mistakes, and the downside is corruption exists, money talks, people getting paid, and like you say, just simply making mistakes. Look at the Ricky Neve case in the UK. Look at it. Look at that case. That it shows you exactly how wrong law enforcement can be and how it can take their eye off the ball and destroy other people. Ricky Neve's mum was destroyed because law enforcement believed that she was the person who did it. Yes, they couldn't prove it, but they put that down to we just can't prove it. But it destroyed her. And then it turns out, 40 years down the line or whatever, it wasn't her. It was nothing to do with her. It was another lad who was then subsequently an adult and got found for it. But it was too late. It's too late. The lives have been destroyed, ruined. And that's why it's so important for people to step on the brakes, to just hold off and understand that mistakes happen. Mistakes do happen, and you have to be right. You have to get all of your ducks in a row and check them and double check them and triple check them. And especially in a situation where you're talking about executing someone now, because make no bones about it, the life that's now on the line is Brian Koberger's. And if they are going to execute this man, they need to 100% be sure that he is the person who did it. And just because News Nation said he did, or Court TV said he did, or Dateline said he did, or Steve Gonsalves feels that he did it, or Christy Gonsalves feels that he did it, that doesn't mean that he did it. The only thing that should go towards the execution of Brian Koberger is absolute fact. Fact. That's it. And at the end of it, when that court finishes and the decision is made, it should be made in a manner that everybody around the table can say, that's the right decision. That's it. And at the moment, in my personal opinion, there isn't enough that we are privy to that does that, that satisfies that. And that's it. There we go. That's me done. That's me done. That's them docs done. Feels isn't evidence. Exactly fucking right, meanie. Feels ain't evidence. Just because you feel someone done something, don't mean they did it. How many times have you been in a situation where you think someone has done something, or you think someone has not done something, and they either have or they haven't, and you've been wrong? Well, attach that to deciding whether you're going to execute that person based on your decision. That's the gravity of what we're talking about. And we're leaving it up to people who have the ability to fuck up, screw up, be wrong, to get this confirmation bias, to be pressurized because of the situation that they're in, the pressure being exerted upon them by the likes of the University of Idaho, who are going to have been feeling the pinch at the time, and they're saying, get it sorted, get it sorted, get it sorted. People panic. And people can be wrong. But anyway, I love you all. Thank you very much for coming and checking out these docs with me. I hope you have a fantastic Friday. I've got another couple of videos coming out during the day, so keep your eyes peeled for them, because notifications are sketchy as fuck at the moment. So yeah, keep your eyes peeled for them. I hope you have a fantastic weekend. I don't know what I'm doing yet. It was the first frost of the morning today, which was great, seeing as Mrs. Harsh thought that'd be very funny to cover me in fucking de-icer after I tried to help her. Now I smell like a can of de-icer. But anyway, I'm out of here. Love you all, and I will catch you all in the next one.